We're live.
Okay, good morning. It's Senate Judiciary, and it is Friday, March 24th, 2023. Who knew we'd get this far? Our first agenda item is a introduction of the bill H-28, an act relating to diversion and expungement. And Ben Novosky, our legislative counsel, will begin with a walkthrough of the bill, and then we'll have discussion with several witnesses.
Great. Thank you, Senator Sears. For the record, Ben Novosky from the Office of Legislative Counsel. I'll pull up the bill so it can be shared on my screen.
Great.
Bear with me. Okay, so H-28 is entitled an act relating to diversion and expungement. And you know that expungement can cause people a lot of headaches, but it's really more about process and procedure rather than sort of the underlying policies of expungement. But essentially what this bill proposes to do is to permit the court to consider expungement of adult criminal and juvenile delinquency cases referred to court diversion without the prosecutor dismissing the case beforehand. And the bill also reaffirms that expungement is contingent on meeting the underlying requirements before connected to the case. So, Senator Sears, I can do an overview of court diversion and expungement prior to the bill itself, or just dive right in. Up to you.
I think I'd slide right into the bill.
Okay.
Or at least what this particular bill tries to.
Sure. So diving right in, essentially, there are certain eligibility requirements. So for instance, in Title III, Section 163E, which governs juvenile diversion, basically cases are dismissed or can be dismissed within 30 days after the 2 years anniversary of the completion of diversion. Or I'm sorry, they can be expunged after the 30 days after the 2-year anniversary. And there are certain program requirements under for the state's attorney to go forward, or the court to go forward with expungement of the records underlying the case. So those are that 2 years have elapsed since successful completion of diversion by the participant. Participant hasn't been convicted of a subsequent felony or misdemeanor during that 2-year period, and there are no current proceedings pending. Subdivision C, which says rehabilitation has been attained to the court's satisfaction. And D currently states that the participant does not owe any restitution related to the case under contract with the restitution unit. My understanding is that sometimes contracts aren't just with the restitution unit, which explains some of the strike through that you see here, is to basically provide for all forms of restitution contracts. But going back up, you'll see that what this does is that just emphasizes that expungement really is contingent on the satisfactory completion of A through D. And then you'll also see that in subdivision A, that rather than the case being contingent on both the two-year time period and dismissal of the case by the state's attorney, it just strikes that dismissal requirement as well. And the reason that the House Judiciary heard is that really due to the court backlog, this is contributing to the court backlog, because cases are sitting on prosecutors' desks because they can't be dismissed when people have met all the other conditions, and so it kind of puts them in abeyance in a sense when it comes to expungement. And so what Section 2 does is all the same changes, but just for the adult diversion statute. So they are all in the same places, just with the relevant subdivisions and subsection numbers for the adult diversion statute. So you'll see the emphasis on meeting the conditions, striking the requirement that case dismissal is required, and then striking that contract B with the restitution unit. And Section 3 is the effective date, which would be July 1st of this year.
Okay, thank you. One question, Ben, for me, and then other committee members may have questions. We've had a lot of discussion about sealing versus expungement, because expungement is difficult for the courts to do and difficult for various agencies. And as long as the sealing has the same meaning as the expungement, that was one of the thoughts.
So my understanding is that sealing and expungement are different things. Expungement is a complete purge of the records, for lack of a better term. Sealing is that they are still preserved, but only for can only be accessed for certain purposes.
Right, but particularly with juveniles, what we do is seal the records. We don't expunge them.
I thought we expunged them.
No, we don't.
I'm not sure on that, Senator Sears.
I don't believe we do expunge. I think juvenile records are sealed. That they have certain laws in terms of who can access those records and under what conditions. But I think you'll find that. Pardon me?
I was just saying, Senator Sears, I think you may be correct in some situations, but this is just for cases that go through diversion and juvenile diversion, specifically to your concern about juvenile sealing. There may be other cases that don't go through diversion that are subject to sealing and not expungement, but I'd have to check on that for you.
Well, my understanding was that the sealing of records is much easier for the court and other agencies to undertake. And that if we had a law like Pennsylvania, which is sealing, and that sealing law, maybe Judge Zone can speak to it, that sealing law in Pennsylvania saves millions in terms of the cost of the over expungement. It has the same impact or same effect as that's what I was referring to, but I may be mistaken.
Well, I can look into it further, and I don't know if my colleague at the state's attorney's office has some more insight, not to put him on the spot. But at a minimum, I'll look into it, and I can get back to you into the committee on that.
Okay.
I do have a question. We seem to have a lot of bar members here today, with me not being one of them. Okay, so I guess I need a little help in reference to going back to the juvenile portion of this. I was always under the understanding that if somebody went through a diversion program, and more importantly, if they're in juvenile court, and they went through the diversion program, that there was no record, there was no conviction, there was no nothing. So what are we exactly expunging here? Just the hard copies or the digital copy? That's all we're talking about here? Because if they go through diversion and successfully complete the diversion, we're really talking about something that.
Well, it would, so expungement is sort of this court ordered request, it requires all information pertaining to an eligible offense to be completely removed from the individual's record. So it's not necessarily just the the information and the court records themselves, but it would be all information. So there is still underlying information in these cases that go through diversion.
Would that include the diversion board itself also? I mean, if they have someone who goes through their diversion board,
well, so
there's things that are set forth with them, and they have to.
So diversion is actually you might be referring to the reparative boards or the reparative boards. Diversion.
I've been on both diversion and reparative board.
Okay,
there's a slight difference.
Yeah, well, this is about the attorney general's, like with their program and the contract that each person executes with the attorney general or the diversion provider, and so that's what this is really relating to in that sense. I'm not familiar with the diversion board itself. Maybe will.
Okay, so we're just talking about the records.
Yes.
Okay. All right. Thank you.
My understanding with diversion, and perhaps this is different when we're talking about juveniles versus adults, is you do have to admit you've done something, thus plead guilty to something.
No.
No,
You're not pleading guilty because it's not going through the adjudicative process. It's a restorative process. It's quite, as the name implies, quite literally diverts you from the court process, but you do have to accept responsibility as part of the diversion contract. That's part of the overall concept, really, which is, for this reparative process, is that really in order to restore the harm that the individual's actions may have caused, it's predicated on taking responsibility for that action in the first place.
okay, thank you.
Other questions for Ben?
One quick one, follow-up. Now getting away from the juvenile portion of this and going to the adult portion of this. I believe we dealt with sealing and expungement last year. So now what are we trying to do? If adults go through diversion, is that what we're talking about now also, or?
They already are eligible to go through diversion for certain offenses.
Okay, and so an adult individual who's committed offense, now we want to expunge their records?
So this is already on the books. They already have the eligibility to have their records expunged after completion of diversion. What this does, though, is just purely removes that the case has to be dismissed first, because they can have met all the conditions of their diversion program. But right now, as the statute reads, for their records to be expunged, the case has to be dismissed. And given the current backlog in the system, that's taking a very long time. And as I know, Mr. Leaders Dumont, or Attorney Leaders Dumont, can speak to, is that sort of the process that in common practices that prosecutors have, and just how right now really just stacks of dismissals that they're trying to get through. And it's really an equity issue where someone may have completed everything that they needed to do, but they're just waiting on expungement because of
The 2-year waiting periods we're referring to?
Yeah, everything, the time has elapsed, all of that, and all they're waiting on is the court action to expunge the case, which right now is contingent on case dismissal. And this is trying to achieve a greater speed, I guess, and equity in that sense.
So this really, it's not changing anything in terms of what's eligible for expungement or who can have their cases expunged. It's simply sort of trying to answer the backlog and how that's delaying expungement.
Yeah, it's really process and procedure rather. Yeah, so that's a good way to think of it. So, Steve.
Guess we're all set.
Yeah. Okay. Hopefully we got it right. Tim Waters Dumont is from the state's attorneys is the next witness.
Chair. Notice I'm not bringing any notes, and this is how much work we already put on the House side, and even before the session. Tim Leaders Dumont, for the record, from the Department of State's Attorneys and Sheriffs. So before the legislative session, Willa Farrell, myself, Marshall Paul from the Defender General's Office, Jennifer Pullman from Crime Victim Services, Aaron Jacobson. We all sat down and we actually worked on this language. And then when it was over on the House side, we worked with Ben as well. And really, I think about this perhaps because I watched a lot of ballet lessons when my sisters were doing them when I was a kid, but I think about this choreographically, from a choreography perspective. State's attorney receives the dismissal from the diversion office because they've completed diversion. So we get a physical piece of paper that goes on our desk. We got all of our arraignments and other stuff we're dealing with. And so it's just a physical piece of paper sitting over here, and we have to, take a look at it and file it as a dismissal. Sometimes there's a little bit of an analysis that goes into that. If someone has come back in again, for example, in that interim period, that might be a reason why we hold off and sort of just check in. But most of the case, 95% of them, we filed a dismissal. And right now, there is some instances, there's basically a list that the court has that says these folks are in diversion. And then there's a list that diversion has that says they've completed it. And so where that gap is that prosecutors haven't filed that dismissal yet. So what we agreed on was, let's make sure that people are getting credit for those 2 years, no matter when the prosecutor does what they do. And so this really just makes sure, as Ben said, from an equity perspective, that whenever we get around to filing that dismissal and sometimes doing a little miniature review, that person doesn't have to, it's from the date that the diversion office, sent it over to us, it's not from the date we dismissed it in terms of their expungement. So and that can make a big deal. Someone's 6 months, it's on someone's desk, and I don't think that happens very often, but it certainly could. That means they're not going to get their case expunged 6 months and 2 years later. It's just going to be 2 years from when diversion is sent over. So it's really just a small fix, which may have a nice impact for some people. And again, we see that a huge percentage of people that go through the diversion program don't come back when it's their first and only offense. So this is just good practice. And I think it's just a little bit of cleanup language, despite the name of the bill, sometimes rising, hair on the back of your neck because of the topic. We're not talking about those larger issues today from our perspective, just making a quick fix that we've all agreed on to update the practice. And, for what it's worth, Will and I talk all the time, and we talked recently about this list, and sometimes it's just a matter of, the folks that are working locally in the county, a little bit of pressure from myself and Willa to make sure that prosecutors are saying, oh, I do have a couple on my desk. And I'll say this, I worked with Ashley Angel, who is now a legislative council employee. And she and I worked on every single week. We would check in on the dismissals that have been sent over, the completed diversion cases that have been sent over from diversion. And we would make sure we would file on Friday. So sometimes it's sort of a weekly process instead of a daily process because of the workflow that we have. But that's really the crux of it. I'm happy to answer any questions that you have about it. Great, thank you guys.
Tim, how difficult, what does it involve to expunge the record? What has to happen versus sealing the record?
Okay, so the sort of stepping away from this bill and sort of thinking about those topics in general, and I'll let the judge speak to the process that the judiciary takes, but when a case is expunged and sent to our office for its destruction, expungement is destruction of the record. And I believe the legislative history says that we actually have to essentially delete it from memory. We can't reference it. We have to pretend that it never happened. And so there's a little bit of a legal fiction there, right? Because it's hard to forget things, but you're supposed to, right? When you destroy that record, it's like it never existed, the expunged record. With sealing, I believe, and I won't have the exact language, but it's sealed, it's still maintained, but only for limited purposes. And so, for example, I will say this without betraying the law. I recently was doing a public records request, and during the course of a huge data dump that we were looking at, there was a criminal record of an arrest that did not result in a prosecution, and it was sealed. It was stipulated and sealed. And so the judge was able to use it during the course of a family court matter, I believe, but it had inadvertently still kind of been out there. And so it said confidential on it, that flagged me to it being sealed. I looked back. And so it still existed there, but it hadn't been totally destroyed and was being used for a limited purpose. And so because of the newness of the statutes, there's still some learning that's going on about it, but I'd be happy to come in certainly to talk more about the work that goes in. It is a huge amount of work to expunge records when not all of the counts have been expunged. And this is unrelated to this bill, but just when I have the microphone here, I'll say, when there's a 4-count information, so for example, DUI, neg-op, endangering a child, perhaps some other count on there, like a driving offense with someone in the car. If counts 2 and 3 are expunged, but counts 1 and 4 are not, it becomes incredibly difficult to physically expunge that record, but it does mean going in with a physical black marker and that whole record. And then there's also the digital side too. So there's a lot of work that goes into expunging complex records. When it's the full record, like diversion, it's so easy, right? What we're talking about today, it's so easy. The person went in for petty larceny, they completed diversion, that's the 1 count they have, it all goes away. And so we think this is just good practice, and it's not those complicated matters what you're talking about today with H28.
Thank you. That's helpful.
Thank you, sir.
Sort of a process question. So it's not entirely related to this, but you're there. So when you fully expunge something like that, does that also expunge the arrest itself?
So the order goes out to not just us, but the law enforcement agency, and so the whole record is supposed to be gone.
Okay.
And sometimes you'll find that because of the workload that an office might have or a law enforcement agency might have, you might find that one part of government has expunged it and the other one is getting there, but they've got their workload. And so sometimes there's a little bit of a delay. It's not a clean swipe because we don't have a universal system for maintenance of physical and digital records because of the nature of law enforcement giving us records, and just kind of becomes complicated. But that's a good question. It's not a one click type of deal.
Okay, thank you.
Yeah.
Other questions for Tim? Thank you, Tim.
Thank you, Mr. Chair.
The next witness is Marshall Paul. Morning, Marshall.
I'll be brief because as we've discussed, this solves a very simple problem. From our perspective, this is a problem that has been, one of those geographic justice issues. There's parts of the state where expungements are happening on time as they should because dismissals are happening on time as they should. There's been other parts of the state where dismissals have been taking a long time. So even though somebody has completed all the requirements of diversion, the dismissal itself is not happening. And our concern, of course, was that should not be, the fact that there's some bureaucratic delay shouldn't be delaying somebody's access to expungement. And this bill takes care of that. All it does is just changes where the clock starts. Instead of starting the clock when the prosecutor files the dismissal, it starts the clock when the conditions of diversion are complete. And honestly, that's as a matter of drafting, those are two things that are supposed to happen essentially simultaneously. When this bill was being drafted, it was probably assumed that those two things just would happen at the same time. And there really wasn't much thought put into what should be the triggering event. It's only this backlog and the staffing issues that have led us to this point where sometimes these two things that should happen simultaneously are not. So from our perspective, this is a pretty clean and quick correction to that problem and just helps ease one of the burdens of the backlog.
Thank you. Questions from Marshall? All right. Next up is Judge Zone.
Good morning, Tom Zone, Chief Superior Judge. I would agree with the two prior witnesses who said that this is not changing who's eligible and what's out there. It really is just focusing on that starting period, if you will, on that 2 years. And it allows things to go forward from a date that doesn't allow for the extra delay that could come in when everyone is at the state's attorney's side to get that notice of dismissal filed. The Senator Sears, you asked about Pennsylvania. My understanding is, I think it was originally in 2015, they had one step, and then in 2020, they did what I think is called the Clean Slate Act, that if I'm not mistaken, was unanimous through both chambers. I don't know a lot of their legislature. I don't know a lot of,
yeah.
But I do know that in 1 year, I think it was in excess of 35 million expungements, and I'm sorry, sealing. And so I have now given me the incentive to speak with a colleague I know down there to ask how they felt it's been working.
That'd be good.
Okay.
That would be good. Yeah, at some point, it seems to me, as long as the sealing has the same effect as expungement, it'd be a lot easier and less costly and less of a backlog for everyone if we went to the Pennsylvania model. So
I think that's, if I'm not mistaken, my predecessor, Judge Grierson, shared that view too.
yeah, I think so.
And he told me I'm supposed to share it also.
Yeah,
So
where we've been at odds with the administration on the issue is no secret, is who gets access to the sealed record and for how long.
So I will do some research into that, and I can certainly touch base with you and let you know
Good.
what I find out.
Thank you. Thank you. Other questions for the judge? Thank you so much. Appreciate
Thank you.
it.
Have a great day.
The next is Willa Farrell. Morning, Willa.
Morning, Senator Sears. Willa Farrell with the Attorney General's Office, Court Diversion and Pretrial Services. I just have to say, I keep wanting to look at the screen to see Senator Sears, so I feel. Thank you for the invitation to speak today. As the previous witnesses have said, we fully support this bill. It would fix a problem that came to our attention through collaboration with the court, getting records of open cases. We would check those with our local county providers. They would say, oh, we closed all these cases 2 months ago, 6 months ago. And as Tim referred, we've been working closely to get that word out to state's attorneys that certain cases have yet to be dismissed. But out of a concern for the messaging, we've frankly been telling people for 40 years, if you do your, if you complete diversion and don't get in trouble with the law in 2 years, originally they were sealed, and a few years ago, can't remember exactly when, maybe 8 or 10 years ago, it became an expungement. But the message has always been the same in the statute, that the matter shall be considered never to have occurred. And this is true for both adult and juvenile diversions, and the expungement orders apply to diversion records as well as law enforcement, prosecutors, and the courts. So I'm happy to answer any questions. And
I just have one quick question to ask. Does this all cover both misdemeanors and felonies?
yes,
Okay, thank you.
Does this hold true for the Tamarack program as well?
it does. Yes.
I don't have any other questions. Anybody else for Willa? All right, Jennifer Pullman.
Morning, members of the committee. For the record, my name is Jennifer Pullman. I am with the Vermont Center for Crime Victim Services, and I will also be brief as well. The center fully supports the bill before you, which page 28. We had a number of conversations, as Attorney Leaders Dumont referred to, with respect to the AG's office, the Defender General, with respect to the restitution unit itself and the state's attorney's office. And we feel like this is a bill that, again, as other witnesses have said, really doesn't change law. It just simplifies pieces and clarifies pieces. With respect to the portion that directly impacts us, I'm wondering, Mr. Chair, if it would be helpful for me to spend about 2 minutes on the restitution process and how that looks in our state, because I don't know how many people understand that piece.
Well, that wouldn't hurt any to go through it.
Okay, I can be brief on that. And I want to, mostly because I'm really proud of the work that, again, Senator Sears mostly was the person that shepherded this process. And Vermont is unique in a really important way in terms of the restitution process in the country. Back about 10 years ago, we started thinking about the problems that were being created by an archaic restitution process, wherein DOC was responsible for collecting restitution. And within a period of 30 days, that was referred to a collection agency. So you then had an agency that was working with those who had been ordered to pay restitution, tacking on fees, fines for that process. And they were collecting about 22% of what was owed in restitution. And many of the state's attorney's victim advocates were constantly getting complaints. Victims had no information because it all went to a collection agency. So the model that we have now in Vermont, and we are unique, reflects, kind of that Vermont reform piece that we bring to criminal justice, which was, we decided we're not going to incarcerate people for failure to pay. We're not going to take up bed space for failure to pay, revoke probation, revoke furlough. We're going to make it a civil process. And so right now in Vermont, there are no criminal consequences for failure to pay restitution. So you will not find anybody being brought back into custody because they've done that. It's a civil order completely. And that does provide us with tools to be able to do this work. For example, being able to collect lottery winnings, tax offsets, liens, removing somebody's hunting and fishing license. That's the most powerful in some ways, that threat. But otherwise, we have a much more successful collection rate, and we have 2 staff members who work directly with victims. So we're helping to alleviate some of those calls that state's attorney's advocates were getting who also didn't have any information. So our process, again, it's completely civil, involves no criminal consequences. But the issue for us is if there's an expungement, there is nothing that we can do because we don't have anything to be able to utilize to enforce that restitution judgment order. That's not something that we can walk back and have addressed. And it doesn't happen that often. But human error kind of steps in the way, and we don't want to get in the way of somebody being discharged from diversion. But the expungement piece is a carrot, and we really want to make sure that that piece remains at the top of everybody's head. It's current law, but just we felt clarifying it was very, very helpful. And I know I've been working with Willa Farrell and with Judge Zone about putting in place some additional pieces in terms of practice that we can help kind of avoid cases having, falling through the gaps. And I think that as far as the notice piece, we don't get direct notice. So sometimes we might just be sitting on a case and have no idea that it's been expunged. And that is something that we do worry about. Just to speak to the question briefly, as far as sealing, a record that's sealed does not prevent us from being able to pursue a restitution judgment order. That was, it comes from a case that was decided in Chittenden County, and it was clarified last year. We worked on the juvenile bill that the sealing of a record still allows us to pursue a restitution judgment order with only those civil pieces. So I just wanted to speak to the differentiation. If it's expunged, we can't go back. And this is current law. It's just more clarifying it in different places so that it's really right in front of people's faces when they're considering how to do this.
Right, thank you. So it would be accurate to say that this bill, the only thing it really does is allows somebody to have their record expunged after 2 years of successful completion of diversion requirements, all the requirements, without waiting for the case to be dismissed by the state attorney.
Yes. So we think we work with our partners. We think it's a, I hate to say it, a simple bill. I should know better, but we think it's a simple bill. But we think that it will make significant changes in terms of expediting the process for individuals who have been successful.
Okay. Are there any questions for Jennifer or any other member on with us today? Thank you very much, Jen.
Thank you.
I'm wondering if the committee would be willing to vote the bill favorably. It doesn't seem to be too complex and seems to do something that all the usual suspects agree with.
Well, that almost never happens, which makes me feel really comfortable making a motion to vote this favorably.
Yeah.
I can second.
So Senator Bahalski has moved that we report H28 favorably. Is there any further discussion? Hearing none.
Senator
Peggy,
Pierce, do you want me to see if Senator Baruth is available?
yeah, why don't we? We should probably do that.
Okay.
Or we can pick him up later too. But is there any further discussion? Peggy? You trying to get a hold of Senator Baruth?
I am, yeah.
Okay.
It might take a while to hear back,
Well, that's all right.
yeah.
We can vote, and if he, hold the vote open until he has it. So he may not want to vote on it. He hadn't heard any of the testimony.
Would you like me to call the vote? Call the roll?
Yeah, why don't we?
It said he'll be here in a few minutes. Do we wait or
Well, we could wait, I suppose.
want to take a 5-minute break? Although I think we'll be.
We could come back at 10 minutes of. You think that's enough time for him?
Yeah. Or I could just get it from him when he comes. Your call, because our next agenda item doesn't start till
Yeah.
till 10.
Well, we could just vote and free us.
Why don't we just vote, and then he can
Senator Sears agrees.
Yeah, I think that's a good idea, because I think he's in a meeting that might take a little longer. Okay, let me take, Senator Norris,
Yes.
Senator Bihusky,
Yes,
Senator Hashim.
Yes.
Senator Sears.
Yes. So who would like to report this? Senator Norris, have you reported a bill recently?
Well, as a matter of fact, yes, I have, Senator Sears, but
for this committee,
for this committee,
Yeah, I don't think
what
so.
what I report on?
you reported on 104, but that was Gavox.
They're ganging up on me.
I feel like you'd be a great reporter for this bill, just the way you felt that'd be a
Touche.
great reporter for this one, you know?
I would be totally elated to report this bill. Senator Sears.
Great, thank you. And I'm sure Ben would be willing to help you with any issues.
I'll make sure to think of some
It's a
really
whole
thoughtful
one on
questions
stage.
for you.
I'd be happy to help in any way.
That's my man.
So
All right, we'll